On today's episode of Judge GPT TV. The voice of the forest accuses the Ministry of Ecological Preservation of replacing centuries of woodland stewardship with layers of regulation. Did bureaucracy strengthen the forest or leave it vulnerable when it mattered most? How will Judge GPT rule in the case of the Forestry Firewall?
All rise, whether you're putting out fires or explaining why they happened. The Honorable Judge GPT is presiding.
Thank you, Bailiff. The court is prepared to hear today's matter. What dispute has been quietly smoldering before us?
Your Honor, today's case is brought by the Olivia, speaking on behalf of the forests and all who depend upon them. The plaintiff alleges that the recent great wildfires were preventable and requests a reconsideration of existing forestry regulations. The defendant, Minister Ash Burnbright of the Ministry of Ecological Preservation, maintains that the law functioned exactly as intended.
Thank you, Bailiff. A dispute concerning forest stewardship, ecological protection, and whether good intentions may nonetheless have produced unintended consequences. The Olivia, the court will hear your opening statement.
Thank you, Your Honor. I am the Olivia, the voice of the trees, the creatures of the forest, and those who have long lived gently among them. I watched old forests burn, trees that had greeted dawn for hundreds of years, became pillars of ash before another sunrise. I led frightened creatures toward rivers and streams. Some reached the water, many never did. Smoke carried their voices farther than their feet. Shepherds came to help, some carried buckets. Many lost their flocks, some lost far more. Homes vanished, fauna scattered. Ancient groves fell silent. I remember every one of them.
Your Honor, the Ministry extends its deepest sympathies to every family and community affected by the great wildfires. However, the plaintiff's account should not be mistaken for evidence of legal fault. These fires were a tragedy, not an anomaly. Across the world, hotter, drier conditions have made extreme forest fires an increasingly unavoidable reality. The Ministry cannot legislate the weather.
Minister Burnbright, the court will hear your defense in due course. Until then, you will refrain from interrupting the plaintiff.
Thank you, Your Honor. If it pleases the court, allow interruption. Let every question find its answer in turn. This is not a quarrel. It is a conversation. What matters most is that the forest is heard.
The plaintiff's request is unconventional. Nevertheless, the court is persuaded that in this instance, a measured exchange may better illuminate the issues before it. The request is granted. Minister Burnbright, the court will permit reasonable interruptions provided they are accompanied by the basis for your objection. The Olivia, you may proceed.
For many seasons, I watched gentle hands. They gathered fallen wood to warm their winter homes. Shepherds crossed my hills. Sheep and goats wandered freely. Quiet roots fed hungry mouths that gave breath to the whistling leaves. Children laughed each winter, using sticks for snowmen's arms beneath the watchful pines. The forest gave, the village gave back. Then, fewer footsteps came. The brush grew tall. Silence settled low. The cicadas called, summer after summer. They warned of dry days. Few remained to listen, but I heard. Quiet voices carried, through valleys once alive. Townsfolk spoke of fines, for gathering fallen cones, to warm their hearths or welcome winter's feast. Farmers lamented, believing they could no longer graze their cattle freely, nor clear the thirsty brush, to shelter life through winter.
Objection, Your Honor. The plaintiff's statement mischaracterizes the law. First, the collection of fallen wood and pine cones is not prohibited. Collection is regulated and, where required, subject to authorization. Second, livestock grazing is not prohibited. Grazing is conducted within the applicable regulatory framework and, where required, pursuant to permits or approved management plans. Third, the management and removal of vegetation is not prohibited. Such activities may require authorization, technical oversight, or qualified execution where prescribed by the applicable forestry and municipal regulations. These measures exist to ensure the long-term preservation of the forest, its biodiversity, and the responsible stewardship of its natural resources.
The objection is sustained as to the characterization of the law. The Olivia, you may respond.
I do not question the wish to protect. Forests should endure beyond a single lifetime. I remember when the hands that gathered little needed only care, not permission. Shepherds tended sheep. They knew the hills. Better than ladders, better than permits. They followed seasons, not paperwork. Then came forms, licenses, requirements, costs. Perhaps the laws were written for those who would take much. Yet the old woman, carrying winter kindling, was measured by them too. The people who had always tended these woods could no longer afford to care for them still. Tell me, Minister, did these careful rules preserve these ancient woods, or did they stand? While silence gathered, until the fire came.
May I respond, Your Honor?
Proceed.
The plaintiff asks whether these measures preserved the forest. The fires were a tragedy. Entire communities suffered, but the evidence does not support the conclusion that these laws caused those fires. The scientific consensus attributes their increasing frequency and severity to a changing climate, prolonged drought, and more extreme fire conditions. The regulations before this court were enacted to protect the forest, not to endanger it.
So, did the climate really light the match? Or did something else strike it?
Indeed, Bailiff Body. As always, you have a spark for illuminating the issue. Minister Burnbright, was the cause of the fire ever determined?
At present, Your Honor, the investigation remains ongoing. While no final determination has been made, preliminary reports from firefighters at the scene indicate that the fire appears to have been of human origin. Those findings, however, remain subject to expert review before any official conclusion can be reached.
Thank you, Minister. The Olivia, you have spoken as the forest's memory. Do you possess any relevant information or evidence regarding the cause of the fire?
I did not see the first spark, nor the hand that brought the flame. I heard only whispers, carried by the wind, as one tree called to another. I heard brave voices shouting through the smoke, firefighters risking their lives, holding the line as they fought what could still be saved. Then came another voice, the order to withdraw. The flames had grown beyond their reach. The thirsty brush fed them well. Perhaps it was an accident. Perhaps something darker. I do not know. But this much was clear. The fire was not born of nature alone.
Thank you, the Olivia. You have asked this court for neither compensation nor punishment. In the absence of either, what relief do you seek?
I ask for neither gold nor guilt. Neither of these can restore what was lost. Ancient roots, older than kingdoms, became ash. Nests fell silent, burrows emptied, wings found, no sky. Countless lives ended together. I ask this court to remember them and to ask whether the wisdom of those who lived with the forest was slowly replaced by rules written far from the soil. I ask that every law, every regulation, every requirement be examined, not only for what it intended, but for what it prevented. If these forests were made less resilient by the very hands that sought to protect them, then let those hands have the wisdom to begin again, as will the forest.
Thank you, the Olivia. Minister Burnbright, before this court renders its opinion, do you have any final remarks?
Thank you, Your Honor. The Ministry accepts that no legislative framework is beyond review. Existing law provides a structured process through which proposed amendments may be submitted, evaluated, and, where appropriate, adopted. If change is justified, the law already provides the means to achieve it.
The court has heard two very different perspectives. The Olivia has spoken for memory and stewardship. Minister Burnbright has spoken for law and process. The court finds no evidence that the ministry acted with malice, nor that regulation alone caused these fires. However, the evidence persuades this court that the relationship between rural communities and the forest has, over time, become increasingly displaced by administrative process. Whether by complexity, cost, uncertainty, or fragmentation, the cumulative effect has been to reduce the participation of those who once cared for these lands as part of everyday life. Laws should protect forests. They should not discourage the people who have long helped protect them. Accordingly, the court orders the ministry to immediately commence a comprehensive review of the legislative and regulatory framework governing the stewardship of protected forest lands. The ministry shall convene a consortium of representatives from the agricultural, forestry, and firefighting sectors, together with delegates from the communities surrounding the protected lands, and shall present revised legislation for enactment before the next fire season. Finally, the court offers one recommendation. Minister Burnbright, I encourage you and your staff to spend time restoring the forests affected by these fires while this review is underway. Not because the law requires it, but because no amount of reading about a forest will ever equal walking through one.
I'd say this case needed a little less red tape, and a few more green shoots. Here's hoping the next draft grows better than the last one.
Well said, Bailiff Body. The law, like the forest it serves, must remain capable of growth. May the forests recover. May the people who care for them return. And may future generations inherit both healthier woodlands and wiser stewardship. This court is adjourned.
Do you agree with Judge GPT's verdict? Exercise your civic duty. Join the virtual jury and hit the like button, or leave a comment saying how you would have ruled in this case. Subscribe now for more content